First case on the docket, case number 118180, State of Kansas v. Londro Emmanuel Patterson III.
May it please the court, Peter Meharry for Londro Patterson. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. In this case, Mr. Patterson was charged and convicted of 1 count of felony murder, 1 count of aggravated battery, 1 count of attempted aggravated robbery, and 1 count of conspiracy to commit aggravated robbery. Those charges came about from an attempted robbery of a gun store over in Shawnee, Kansas back in January of 2015. The evidence the state presented at trial was that an individual by the name of Mr. Wiley entered the store, talked to the owner, Ms. Beaker. A little while later, 3 other individuals, one of which was Mr. Patterson, entered the store. They pointed guns at the owner and attempted to rob the store. The other owner of the store was in a back office. When he heard the commotion, he came out shooting. At the end of the day, the owner who was in the back office was shot and killed. My client was also shot. Mr. Wiley was shot and is paralyzed, my understanding, from the waist down. And then a 3rd individual in the group was also shot. As I said, from that, he was convicted of felony murder, along with the associated felonies of attempted aggravated robbery, conspiracy to commit robbery, and aggravated battery. In our brief, we've raised several issues, and I'll start with the first issue, and it's our position that the felony murder statute is unconstitutional. The problem that we see with this, kind of twofold. We believe it violates due process as well as my client's right to a jury trial. And it does this because it does not require a finding of criminal intent, and we believe that there has to be such a finding, and that finding must be done by the jury. Specifically, we believe that it must be a criminal intent as to the homicide in this case. The state points to the doctrine of transferred intent that it says underlies felony murder, but we believe there has to be a specific intent as to the homicide, and that if you use the underlying intent on the felony and transfer that up to the murder, what you are asking the jury to do is find criminal intent to the felony, and then it's a mandatory presumption that that satisfies the underlying homicidal intent for the felony murder conviction.
Counsel, the case law in applying that principle to the felony murder statutes across the country is pretty lopsided against you. So why should we be a trailblazer?
Your Honor, the case law on that is all across the country. It is long-standing. We recognize that. But I think the problem we see with it is when you look at how Kansas has, in the recodification, it talks about culpable mental state is required for every offense. It doesn't make an exception that if you prove culpable mental state for one felony, you can use that for another felony. It just says culpable mental state is an essential element of every crime defined by this code. So we believe that that requires something other than intent to commit the felony. It requires an intent to commit a murder. If you are going to, we talk all the time about in criminal law, you have kind of the confluence of the criminal intent and the criminal act. And that's what we believe you need here, but the criminal intent doesn't follow the criminal act. It doesn't follow the killing.
Counsel, I know we agree that criminal law is all statutory, right, at this point in Kansas?
Certainly.
Why doesn't the legislature get to define the intent for felony murder as the intent for the underlying felony?
They can, but I don't think they did. They don't say that in the felony murder statute. It doesn't say with the intent to commit the underlying felony.
Do they have to say it in that statute as opposed to reading all of the statutes together, including the culpable mental state statute?
Well, I think our argument is that there is that requirement via 5202. Because that does require a culpable mental state unless
Right.
plainly disposed of. And the legislature, I don't think, when 5202 was recodified and included that plainly disposed of language, they did not change the felony murder statute to plainly dispose of that. So we believe there is a requirement when you read 5202 that there is that homicidal intent for a felony murder. And the problem we see then is the jury never made that finding. They don't make that finding under the felony murder statute. They make a finding as to the intent to commit the underlying felony, in this case the attempted robbery, but that is not the same thing in our view. And that is something the jury needs to do. My client has a right to have a jury find all of the essential elements beyond reasonable doubt, and in this case, under the felony murder statute, that was not done. The second issue deals with jury nullification, and I certainly recognize, I filed a 609, I believe, that this court a few weeks ago came out with Boothby that talked about jury nullification. Couple, I would say, quick comments about that. One of the issues this court found in Boothby was that nobody talked about where this right came from. This court defined it as a power the jury can do. They want to get back in the jury room and just say, we're not going to convict. That's kind of their inherent power. But it questioned whether or not there was any right. And in our brief, we point this court to KSA 6247D. That deals with jurors, and they must swear or affirm to try the case conscientiously and return a verdict according to the law and the evidence. And we believe that when you include that word conscientiously in that oath, the jury does have that right to say, this isn't right. A conviction in this case is not right. And even if it's proven, they've shown all the elements, we just don't think it's right. So that means the jury can say, no, we're going to acquit. So we believe that there is a basis for that in the statutes. I would also argue that I see the jury nullification as a right that's part and parcel with the right to a jury trial. Jury trial has always been seen as a check on the state, and the jury in that role can get back there and say, no, the state's overstepped in this case, or they've overcharged, or this conviction would be morally wrong for whatever reason. So
Well, these instructions told the jury that it should convict, if the state provided all the elements of the charged offense. It doesn't say you must, which is where there's been the sensitivity. So, we've been defining should ever since I was in high school debate,
But I think
ought to, but not necessarily will. So I don't understand why you're not okay on this one.
I think the problem with should as it implies what the jury should do. And that is in the instructions that are coming from the district court. And the jury should be able to go back to the jury room and decide for themselves without any pressure from the district court or the state saying this is what you should do. The state can get up there and make their arguments, but the district court should not tell the jury this is what you should do. If you
Shouldn't
find
tell
A,
the
B,
jury
C.
to follow the law.
It
And
should
that's
tell
what these
the.
instructions do.
I would argue that it should tell the jury what the law is. Period. It should tell the jury if you find each and every element, you can convict. But to go
So
that one step,
it's advisory to follow the law?
I would say that the jury has a right to nullify and not follow the law. Should they? Maybe we can all talk about that. But that's the jury's decision, not the district court's. And I think that's where it goes one step too far when the district court is saying you should do this. It's putting the jury in a box where the jury should not be. It can go back there and say, we're not going to convict. I don't care what the evidence is. That's the jury's role. It's a check on the state, it's a check on the government, and it's a protection for my client.
So, counsel, do you want this court to take us back to McClanahan, where we instructed the jury to just do what you think's right? You don't need to follow the law. Just do what you think's fair.
I don't think you have to just instruct the jury do whatever you want. I think you can instruct the jury this is the law, and if you find A, B, and C, you can convict. I think the instructions as written go beyond that.
When I took an oath to be a judge, I took an oath to follow the law. In a jury trial, the jury sits in my shoes as a fact finder. Why don't they have the same responsibility as I do?
I would point the court back to 6247, where it says the jury is sworn to try the case conscientiously. That doesn't mean that they're robots, and if the case is proven, they have to convict. They have their morals, what they believe is right and wrong, and they can say to the state, no, conviction in this case is not right despite the evidence.
PSA 6247D
Correct.
requires the administration of an oath to the jurors.
Yes.
And that oath reads, the jurors must swear to affirm to try the case conscientiously and return a verdict according to the law and the evidence. So you're asking us to basically judicially repeal that statute, that direction from the legislature?
I don't believe we're asking you to repeal it or alter it in any way, but give effect to the words in that statute which tell the jury they can try the case conscientiously.
But according to the law.
Right.
And all this instruction does is tell them to apply the law, or that this is the law that guides the.
I think the instruction goes beyond that and tells them they have to. I think you can instruct a jury, this is the law, this is what the state has to prove, and if you believe they have proven that, you can convict.
What is the opposite true? Can the jury ignore the evidence evidence that doesn't support the verdict and say, I don't care, I think he's guilty, and convict? I mean, essentially, under your theory, that's okay too.
Theoretically, a jury could do that. I've never sat on a jury. I don't know that I know exactly what goes on. But I think the jury has the right and the ability to come to a conclusion it sees as right, even if that goes against the evidence. And I think the instructions as they are written pushes the jury not to do
given
that.
your position, there would be no evidence to support, or little evidence that doesn't meet the burden of beyond a reasonable doubt. And under your interpretation, that would be okay if they convicted?
If there is insufficient evidence to convict and the jury convicted, I think that we
Under
argue
your
that
theory,
happens.
I guess that's okay.
And we argue that happens. We come to this court and says there is insufficient evidence to convict. And I think if there truly is insufficient evidence to convict, this court would have an obligation to reverse. But, I think what I'm getting at is the jury gets to decide the case. And it should not be with, I believe, unduly persuasive or burdensome instructions that push it to do what the court thinks it should do. The jury is the ultimate decider, and they should be given instructions so that they know that.
We would have to reverse Boothby or overturn Boothby to get to where you want us to get to, right?
I believe you would, because the instructions are the same. The instructions we complain about in this case are the same as those in Boothby. I'm exactly out of time, and I would ask this court to reverse and remand this matter as we've argued in our brief.
Counsel, we did take a lot of your time with our questions. Do you feel you need about 30 seconds to summarize? Or you think you've made your points?
I think I've made my point, Your Honor.
All right, thank you, counsel.
Mr. Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the appellee, the plaintiff, the state of Kansas. Londro Patterson aimed a loaded handgun at Becky Beaker when he entered that retail store that day when she was the sole clerk behind the counter. When he did so, it was part of a coordinated attack between himself and 3 other individuals that came to attack Becky Beaker that day. It was a failed effort to rob her because her husband came to her defense when he stepped out from the back room, unexpectedly to the 4 robbers that were accosting Becky Beaker. When he came out from that back room, that's when he and one of Mr. Patterson's co-defendants engaged in a gun battle, and John Beaker was killed. Mr. Wiley was shot as well. In that attempt, when John Beaker was killed, that was something Londro Patterson, as well as his 3 co-defendants, was absolutely responsible for under Kansas's long-standing felony murder rule. That longstanding rule is in accordance with rules across the country. It is not constitutionally infirm, and it carries all the necessary elements for a criminal offense in the state of Kansas.
Counsel, I just want to take care of some housekeeping. The constitutional challenge was raised for the first time on appeal, and defendant followed the procedure of trying to explain why we should go ahead and decide that case. You didn't oppose that, so you're okay with going to the merits on this one, right?
I am, to the extent that, unlike a constitutional challenge that you'll hear later this morning in another case, this one is not dependent upon the facts of the case. This one is purely a legal question that I realize that this court is in a position to resolve on the merits. But the felony murder statute is firm constitutionally. The state, opposing counsel mentioned this morning that the state argues a form of transferred intent exists within the felony murder statute, but that is not the state's argument. There's no transferred intent here. We're not arguing that the intent of the underlying felony transfers to the killing. My argument, as outlined in the brief, is that there is no intentional requirement for the killing itself at all. There's no culpable mental state for the killing. The killing can be unintentional in the case of felony murder by the defendant in this case. What the premise of the felony murder statute is, when you engage in one of these inherently dangerous felonies, such as armed robbery, you are assuming the responsibility for the consequences that follow, which are very foreseeable that a death may occur. That is a longstanding principle in Kansas law going back, I cite to cases from the 19-teens and 1920s.
It is kind of a strict liability crime, is it not?
It absolutely is, in a sense.
Is there any problem with strict liability crimes from a due process perspective?
There's not, because the defendant and any others in Kansas are already put on notice about this offense. They're put on notice that when they engage in an inherently dangerous felony such as...
Is there any limits? And I understand that, and of course, it's true, felony murder pre-exists our statutes. I mean, there's a long history of the felony murder rule. Are there any limits on strict liability crimes? Are there any constitutional limits, due process limits? Could the legislature just make anything a strict liability crime?
Anything other than actions which are constitutional rights of a defendant, I suppose. The legislature couldn't criminalize things that implicate the First Amendment, for instance, or things like that. But the legislature can create laws that are strict liability criminal offenses. They do so throughout the criminal code. They do so in traffic offenses. They do so in DUI. They do so in statutory rape contexts where the defendant is not required to be aware of a victim's age and so on. So I don't see any infirmity in this statute, and I can't envision one other than those that could implicate constitutional rights of a defendant. When I say that this is firmly entrenched in Kansas law, I quote several cases within the state's brief, and one of them that is particularly applicable in this case is State v. Branch in 1978. It states, the impulse for an individual to resist the sudden show of force, to defend himself or to come to the aid of a family member or loved one is a basic human instinct. And under such circumstances, every robber who expects human opposition to his quest to steal, as he must when he commits a robbery, is a potential assassin who knows he may be forced to use his weapon. That's precisely what occurred here. It's precisely what occurred here because in these four men's efforts to rob Becky Beaker, they met resistance in the form of John Beaker when he emerged from the back room. And that's when a gun battle ensued. And that's when John Beaker was killed. And that's why Londro Patterson is responsible for his death. If the court has any further questions on issue number one, on the felony murder statute and the culpability requirement, I'd welcome them. But with the limited time I have, I'd like to also briefly address the other issues that have been raised here. On the second issue that was mentioned this morning on jury nullification is not a right of a jury. It's not a right of a defendant. Jury nullification is a power that exists not by virtue of statute and not by virtue of this court's rulings. It's a power that exists by virtue of there being no remedy. There's no remedy because if a jury acquits on a theory of nullification, if it ignores the law and acquits a defendant, there's no option for the state. There's no remedy there. The state cannot go back and get a new trial arguing essentially the converse of insufficient evidence. We can't come here before you upon an acquittal and say there was a super sufficiency of evidence. You should overrule the jury's verdict here because the state proved every element. We can't do that. So the power exists by virtue of there being no recourse and no remedy. In this case, these 12 jurors that went back to the jury room were not sitting back there parsing the fine distinctions of should versus will versus must and so on. If a juror is inclined to ignore the instructions and to ignore the elements of an offense, they're not going to be persuaded by a should in a single instruction. Jury nullification, by its own definition, is tossing out the instructions, is ignoring the law. So it's hard to envision a scenario in which a juror would be inclined to nullify, which is to ignore the law, but then be persuaded otherwise by the should in this instruction. If they're so inclined to do so, they're going to do so by ignoring instructions such as this one. Issue number 3 on the state's arguments to the jury that it had a duty to follow the law. That is a correct statement of the law, and that flows from the very instructions that were at issue in question number 2. The quest in seating a jury during jury selection is to find jurors who will follow the law. And when the state inquires of them about their biases or about their ability to follow the law, the state often uses the example, for instance, of marijuana possession and whether or not individuals sitting on a panel would be inclined to ignore the law if they disagree with it. Those types of questions often come up in jury selection because that's the state's efforts to seek out jurors who may be inclined to disregard the law and substitute their own policy decisions or rationales for that of the legislature. And vetting that out during jury selection is a proper role for the state to take. That's what they did here. After all, refusal to follow the law is grounds for dismissal from a jury. So, by the converse, the state inquiring about a juror's ability to follow the law is an appropriate inquiry for the state to make during jury selection. Issue number 4 was not mentioned at the outset of this argument, but I'd like to touch on it briefly, the constitutionality of the Hard 25 law under the 8th Amendment and the Kansas Constitution. The argument has been made that it is a cruel or unusual punishment and that it should be reversed as such. The case-specific challenge, this argument takes 2 forms, the case-specific challenge as well as the categorical challenge. The case-specific challenge here, well, both challenges were unpreserved because they were never made below. They were never made at the district court. But specifically, the case-specific challenge is one that requires preservation. It requires preservation because at least one of the 3 factors that are examined in a case-specific challenge under the 8th Amendment in the Kansas Constitution requires a review of the particular facts of that case. In State v. Robeson, this court recently stated in 2010 that because a case-specific challenge requires those fact findings on several factors, it will not be reviewed for the first time on appeal. The same rule applies here. In that case, the Hard 25 statute, the Hard 25 penalty for aggravated indecent liberties on a child was the challenged statute, but it was not taken up on the merits in that case because it wasn't preserved. It was later addressed in another case, in Ruggles in 2013. That's the case in which this court upheld the constitutionality of the Hard 25 statute for aggravated indecent liberties. Aggravated indecent liberties is a charge that does not involve the death of an individual as a result of the offense at the time, but that Hard 25 statute was not found cruel or unusual in that context. In the context of felony murder, a charge which necessarily involves the killing of another person, the Hard 25 statute remains firmly constitutional. The factors that are examined in a case-specific challenge include the nature of the offense, the nature of the offender, and the danger presented to the public. I see no way to argue that any of those 3 factors don't support finding this statute constitutional. The nature of the offense, this was a particularly violent one. 4 men attacked a single female store clerk behind a counter at a small store in Shawnee, Kansas. The nature of the offender, he was a few days shy of his 20th birthday. when he stormed into that store and put a gun to Becky Beaker's head, he had already accumulated 2 felony convictions involving weapons offenses in Missouri. And he had an outstanding warrant out of Missouri for another armed robbery in which he shot a store clerk in the head. The danger presented to the public by this particular offender is obvious, and that factor does not weigh in his favor.
Does age factor in at all?
In the context of, I don't know that, let me back up. To the extent that
that's
age,
the point the appellant's making is the age is under 20, close to 18. Does that factor in?
to the extent that that factors in, his argument is that someone who at that stage in life has not had the same life experiences and so on is not as well learned perhaps. I think the converse is true though in the case of a hard 25 challenge. And the reason I say this is Mr. Patterson, being convicted of this offense, being in custody since he was about 20 years old, receiving a hard 25 sentence, he received other sentences on other counts, but setting those aside for purposes of this argument, Mr. Patterson stands to go before the parole board in his mid-40s, even though he was responsible for the killing of another individual. So to the extent that age can be factored into the case-specific challenge, this is far from cruel or unusual. He has a huge portion of his life he stands to live outside of prison, but when he gets before the parole board in his 40s. So to the extent that he argues age weighs in his favor, I argue the inverse, for different reasons. The comparison of the sentence for more serious offenses, I lay out in the state's brief the spectrum of offenses in Kansas that involve killing of another individual and how the hard 25 for felony murder lies somewhere right in the middle, which is seemingly appropriate. It is not as harsh of a sentence as that which is implicated by the intentional killing of other people or capital murder statutes, for instance, but it is a more harsh sentence than other killings that don't involve the type of violent underlying felony as is the case in felony murder. And then finally, the comparison to other jurisdictions by the defendant's own account in his brief. Kansas is well within the median, well within the norm of other jurisdictions that criminalize felony murder. The categorical challenge is the one that does not require a review of the particular facts of this case. That is a question of law, which reviews the proportionality, essentially, of the sentence. And it reviews other factors. It reviews the hard 25 in the face of a national consensus, which, as I stated under the case-specific challenge, the national consensus is in agreement in accord with Kansas and its penalty for felony murder. Legislation remains the clearest objective evidence of contemporary societal values, and that's where a penalty can be revised if society so wishes, and Kansas is in the mainstream. But the second factor under the categorical challenge through the Graham case is the judicial exercise of independent judgment, and that calls for a review of 4 factors. It calls for a review of the applicability of retribution, deterrence, incapacitation, and rehabilitation. With the limited time I have left, I'll rest on the brief regarding several of those factors, but I'd like to point out the applicability of rehabilitation in the context of the hard 25. The hard 25 sentence is a sentence that is perhaps uniquely, exclusively well suited for the rehabilitation context in Kansas. When a prisoner goes to prison on a hard 25 sentence, he's not guaranteed parole at 25. It is a 25 to life sentence. But if he participates in programming, does well in prison, furthers himself, achieves an education perhaps, avoids disciplinary problems, those are all going to be things that go in his column when he first appears before the parole board. So rehabilitation is something that is particularly well incentivized by the hard 25 statute. I recognize I'm out of time. If there are no further questions, I'd ask this court to affirm Mr. Patterson's convictions and his sentence.
Do we have any further questions? All right, thank you, counsel.
Thank you.
3 minutes for rebuttal.
I just have a quick comment in response to Justice Steagle's question about limits on strict liability offenses. I would point the court to 215203. That is guilt without culpable mental state. And that states that a person may be guilty of a crime without having a culpable mental state if the crime is a felony, and the statute defining the crime clearly indicates a legislative purpose to impose absolute liability for the conduct described. So I think there are limits on strict liability offenses, and I think when we talk about strict
What about traffic offenses? I mean, maybe we're straying far afield, but
Well, and what I was going to say was, when we talk about strict liability offenses, I think we usually talk about very low level or kind of administrative regulations, stuff like that, as opposed to what carries the harshest sentence in Kansas.
I'm not sure there have been actual court holdings, but there have been lots of discussion recently, even at the U.S. Supreme Court, about, some people talk about mens rea reform or what, and that's this question of, is it constitutional to criminalize behavior that doesn't have a mens rea? And that seems to me to be your argument.
Our argument is that you have to have, particularly when you're talking about felony murder that carries a hard 25, you have to have both the criminal intent
Wouldn't
and
that,
the criminal
I guess,
act.
yeah, so since you brought it up, wouldn't that really disrupt our entire criminal code? I mean, because we traditionally have quite a few offenses that don't carry a mens rea. I mean, don't carry a culpable mental state.
Well,
You're
guess-
guilty of speeding even if you didn't mean to speed, and it was a complete accident.
I guess arguably, I would say I don't think it necessarily would disrupt the criminal code that much, because you look back at 5202 and they say culpable mental state is an element of every offense unless the statute plainly disposes of it. So I think we're starting with the basis that you have to have that criminal intent, and I don't think we're throwing hand grenades into the statutes. I think what we've recognized and what 5202 and 5203 try to show is that you have to have that criminal intent to go with the criminal act. I have nothing further to add and would ask the court to reverse for the reasons we stated in our brief.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement